So tonight, this is now the week 8 of our course in LAWS12061, Administrative Law. And we continue with group presentations pertaining to a factual problem, event, or issue related to administrative law. If we would have had time, then we would have covered 2 of the tutorial questions that are up for tonight. But we probably won't have time for that, so which means that if you're interested in knowing what the answers are to the tutorial problems, I'll be posting the Microsoft Word answer in Moodle. And so tonight we have the pleasure of having 4 groups doing their presentations. We have the Legal Eagles, which will be the first group to do the presentation. Then we have Team Cat, the Drakes, and then Triple Threat. Given the fact that we have 4 groups doing their presentation tonight, we don't really have enough time to allow anyone to go beyond the allocated time. So please stick to your time limits, and I'll be closely monitoring the time. We now begin, hang on, it's recorded, yep. So we now begin with the presentation by the Legal Eagles, to be led by Amelia Thomas, as well as Joanne Stephenson.
Can I share my screen?
Yes, please go ahead.
I think that you've got to jump off first.
Hang on. Okay, there you go.
Hi guys, my name's Millie or Amelia Thomas. My group member is Joanne Stephenson, who should be joining us shortly. We chose a case that showcased what we believe to be an error of law and some questions about court procedure. So the story is around the case Construction, Forestry, Mining and Energy Union versus the Director of Fair Work Building Industry Inspectorate. In a recent case heard in the High Court of Australia in 2015 and 16, the CQUMEU, the plaintiff, was seemingly dealt jurisdictional.
Hello? Millie, you've got cut off.
Injustice by Justice Collier in proceedings against the director of, the director began proceedings in 2015 in seeking declarations that by their conduct, 5 CQUMEU officials had contravened Section 500 of the Fair Work Act 2009. And as a result of the operate body had also contravened Section 5. I'm sorry, excuse me. So I'm really extremely sorry. CQUMEU considered that all 5 of its officials had contravened Section 500 of the Act, and as a result of section that was supported by various precedents in that court. A statement of facts that both parties agreed on was filed before Justice Collier in preparation for the
Millie, can you speak more slowly? You're speaking too fast.
Sorry.
More slowly.
On the 25th of November 2015, Justice Collier heard submissions on the basis of the agreed statement of facts. There was an oral argument, orders made on 10th of December 2015, and further written submissions filed on 29th of February 2016 and 25th of March 2016. However, on 16th of May 2016, while judgment stood reserved in the case, Justice Charlesworth delivered a judgment in an unrelated case which showed a different interpretation of Section 793 of the Act. His judgment found that the section does not fix upon a body corporate liability for contraventions found to have been committed by its officers. This judgment contradicted Justice Collier's findings. As a result of Justice Charlesworth's findings, CQUMEU sought to file an interlocutory application for leave to withdraw the Section 793 admissions, which incriminated the corporate body from the Abbey Registry of the Federal Court. The application was stopped by Justice Collier on 2nd of June 2016, who ordered leave be granted by the court before filing. She refused the application on 19th of July 2016 and stated that the principles to be applied where a court is asked to hear further submissions after a judgment has been reserved had been stated by that court in previous precedents. Justice Collier said additional submissions filed after judgment had been reserved would not be accepted except in very exceptional circumstances, to which she concluded there weren't any. This statement was consistent with other decisions made within the court. Justice Collier also rejected CFMEU submissions that the refusal of their interlocutory application would cause injustice, as it bound CFMEU to the true operation of the Section 793 and was contrary to law. She said there was existing authority within that court that supported her interpretation of the section. Justice Collier concluded that the interests of justice did not require that the CFMEU be given leave to withdraw the admissions and upheld that CFMEU had contravened Section 500 of the Act. Justice Collier made orders imposing penalties for each such contravention. We highlighted two issues within this case. The two issues within the topic issue, construction forestry mining energy union, the plaintiff, versus Director of the Fair Work Building Industry Inspectorate, the defendant, refer to administrative law rules or principles. The first issue.
Hey, Millie.
The section of an interlocutory submission from CFMEU by Collier J was supported by principles held when submissions are made after judgment has been reserved, case management principles from court precedents, and Section 37M of the Federal Court of Australia Act 1976, addressing the overarching purpose of civil practice and procedure provisions. The principle about submission made after judgment has been reserved in Autodesk versus Dyson, included comments from Chief Justice Mason, who said, "It must be emphasised that the jurisdiction is not to be exercised for the purpose of re-agitating arguments already considered by the court, nor is it to be exercised simply because the party seeking a rehearing has failed to present the argument in all its aspects or as well as it might have been put. What must emerge in order to enliven the exercise of the jurisdiction is that the court has..." Is that you, Joanne? Would you like to jump in?
Yes, sorry, Manuel. I actually had problems with my internet. It wouldn't connect through. So I'm Jo, and I'm happy to actually jump in if that's okay. What must emerge in order to enliven the exercise of the jurisdiction is that the court has apparently proceeded according to some misapprehension of the facts or the relevant law, and that this misapprehension cannot be attributed solely to the neglect or default of the party seeking the hearing. Principles about case management were addressed through reference to A1 Risk Services Australia Limited and Australian National University, which highlighted Regulation 21 Court Procedure Rules 2006 ACT by Chief Justice French. It said the purposes stated in Regulation 21 reflect principles of case management by the courts. Such management is now an accepted aspect of the system of civil justice administered by courts in Australia. Regulation 21 of the rules stated, the purpose of this chapter and the other provisions of these rules and their application to civil proceedings is to facilitate the just resolution of the real issues in civil proceedings with minimum delay and expense. Accordingly, these rules are to be applied by the courts in civil proceedings with the objective of achieving the timely disposal of the proceedings and all other proceedings in the court at a cost affordable by the respective parties. The parties to a civil proceeding must help the court to achieve the objectives.
Section 37M of the Federal Court of Australia Act addresses the overarching purpose of civil practice and procedure provisions, highlighting the overarching purpose of the civil practice and procedure provisions is to facilitate the just resolution of disputes as quickly, inexpensively and efficiently as possible. The second issue, the interpretation of Section 793 of the Fair Work Act 2009, which by Justice Collier's findings bound the CFMEU as a corporate body to conviction, contradicted later findings by Justice Charlesworth in Director of the Fair Work Building Industry Inspectorate versus Robinson. The Act states that any conduct engaged in on behalf of a body corporate by an officer, employee or agent of the body within the scope of his or her
You've got 30 seconds to go.
Or by any other person at the direction or with the consent or agreement, whether express or implied, of an official of the body, if the giving of the direction, consent or agreement is within the scope of the actual or apparent authority of the official, is taken for the purposes of this Act and the procedural rules to have been engaged in also by the body. Justice Charlesworth said Section 793 does not of itself fix upon a body corporate liability for contraventions found to have been committed by its officers, employees or agents.
Millie, I've got to stop you there. It's not that you've used up 7 minutes. Okay. I wonder if I should begin with my comments. Yeah, Millie?
Oh, so sorry. I thought it was 12 minutes.
Yep. 7 minutes is for you to present the facts and the issues. 5 minutes is for us to ask questions. Okay. Would there be questions from the group, from the rest of the class? Okay. Let me just make my own comments first before we get to the part of getting some comments and questions from the class. I'd like to provide feedback, again, for the purpose of giving some suggestions on ways by which future presentations could be improved. So this is purely, how do you call it? It's part of a learning activity, a learning process. Now, if you are to make a presentation, it is always better for you to just come up with bullet points, key points of what you are presenting. Avoid reading text. The problem is, and you've probably experienced this, it's so difficult for people to both read what's on the screen and then listen to at the same time. It cannot be done. Cognitively, that's called cognitive overload. So you either talk to them and you allow the visual cues in terms of the bullet points to enable the listeners to get a better sense of what you're saying, but you do not overload them with information. So that's one. Secondly, there is just too much information that's there, which I suppose is really just a method of copying what's in the Microsoft Word document. So you should summarize what's in that document that you submitted and just put the summary there as a way of guiding you on what you should be discussing. And thirdly, as I pointed out to Millie earlier on, she was just speaking too fast. Okay, so, okay, now, the main issue I have really is that so far, I'm trying to get a sense of what the administrative law factual problem, event, or issue here is. Can you enlighten me on that? I'm getting confused. What exactly is the administrative law problem here? Event or issue?
The issue that I found was the interpretation of Section 793 of the Act by Justice Collier. It was applied in one interpretation by Justice Collier in one case, and then it was applied in a different way by Justice Charlesworth in a different case. So I thought it might be an error of law.
So why is that an administrative law problem? What exactly, in essence, what is administrative law about? And then relate that question to my question, which is, what is the administrative law problem here that you're dealing with? What is the essence of administrative law?
In the correct administration of the law, isn't it?
Okay, yeah, that's a bit too broad. So how does administrative law do that?
In various ways. I'm so sorry, I've been put on the spot. I can't really think straight at the moment. I'm so sorry.
Would anyone wish to help? At the core, when we examine administrative law problems, what is inherent? What is in an administrative law problem? Okay, so the answer is, if you look at administrative law, it essentially is involved with trying to minimize or limit excesses of the executive or of administrative agencies when they make decisions that impact on citizens, especially their rights, interests, or legitimate expectations. So there is often a decision that is made by the executive. So it is not about an error of law, because if it is an error of some judges, if there is some contradiction in whatever legal rulings that they've made, that has nothing to do with administrative law. Our focus, the focus of administrative law always is that there has been a decision that has been made by the executive or by an administrative agency, which impacts on citizens. And that is why administrative law came in as a way by which citizens can then find ways by which their rights can be protected, not through the court of law, but through an administrative process such as a merits review. So that is the focus of administrative law. And that seems to be missing here. So that's just a comment of mine. Comments from others or questions? So I am raising that point because you have a chance of doing something in relation to the individual research essay. I wonder if I was able to provide feedback to this, because if I did, this wouldn't have happened. I did not. You did not submit anything to me. Yeah, okay. So I wouldn't be surprised. Yeah, it's unfortunate. Had you requested feedback, I could have provided it, and we could have avoided this problem. So I would suggest Joanne and Millie, we need to get in touch with each other again, because if you go down this path, pursuing this in your individual research essay, you're going to have a problem, because you're not dealing with an administrative law problem. This has nothing to do with administrative law so far. I can't see anything. Okay, so having said that, as I said, my purpose here is not to embarrass you. It is to provide feedback, and let's talk to each other again by email, and let's sort this out. I think there should be enough chance for you to do something about this. Okay, Millie and Joanne, so thank you for the effort. I wish I had an opportunity to provide you feedback sooner. Okay, and so thank you for the presentation. And yep, let's get in touch again with each other again. Okay, thank you. I'd like to move on now to the next group. That would be Team Cat. Would you be ready?
Manjo, we're
Yeah.
the one that had to
Right.
the absence of one of our members this week.
Okay, so in that case, we move to so we've been given an extra 12 minutes. Would anyone else have any comments or feedback or questions for the group, for the Legal Eagles group?
Hello, can I just say something here? Because
Yes, please.
you've listed on your message of the week, Drake's Fantastic Four, Legal Eagles, and Triple Threat as being the presenters of this week.
That's right.
I think you're using if you've still got cats on your sheet, you're not using the most up-to-date crib sheet.
Fantastic Four sent an email asking for a chance for them to present next week. So
Okay.
we won't be presenting this week either.
Oh yeah, well, cats shouldn't have been on the list. Okay, no, that's all right then.
Okay.
I was just nothing. Just checking.
So who's going to be presenting next? So it's not going to be the Team Cat. So it's going to be the Drakes. Okay, but before we go there, we've only got two teams doing the presentation. Would anyone else wish to provide any comments, feedback, questions to the first group before we move on?
Okay, can I then ask a question, probably of you?
Yes.
If this case that the Legal Eagles have put forward is an error in law, as they potentially say, how do you get from the original tribunal decision to presumably the federal court who can make a decision on law without going through the administrative tribunal? Is there a separate? Do you just go straight to the federal court or the high court or something to get the question of law sorted out?
I could answer that, but I need to get more facts.
Well, I'm only talking about the case that was presented by Legal Eagles,
That's right.
which said there was a different interpretation of the statute.
Yeah, I actually had a problem there trying to keep abreast of the facts. So what exactly were the facts there?
Well, loosely speaking,
Yep.
there was a section in the Act that was used to make a decision on the basis of what it said in the Act. But what they presented was that particular section had been interpreted by one judge one way,
Okay.
and then it had been interpreted by another judge in a different way. So the appeal to the administrative tribunal, I gather, was to decide which interpretation of the statute was correct. Unless I've misinterpreted their presentation,
Yeah.
but that's what I thought they were saying.
That would never happen.
Well, it shouldn't happen.
Yeah, for the simple reason that it is not for the Administrative Appeals Tribunal to determine questions of law. So if you
I
have,
know. So, okay. So now that we've established that it's a question of law,
yeah,
what's the route for getting a question of law sorted? You go straight, ignore the tribunals altogether, and go straight to the federal court or something?
no, it all depends on the facts. So
Yes.
in the facts, I'm not even sure why the Administrative Appeals Tribunal came into view. That wasn't
No, I understand that. But my
Okay.
question is, what do you do if you don't want to go to if you have a tribunal decision that you don't like,
Okay.
and it's not a matter that can be dealt with by the administrative tribunal?
Mm.
Is there I don't know, I mean, I probably should know, is there a process whereby you go directly to federal court without going to the administrative tribunal?
Okay. So let me clarify. So in the question you have, Tony, you're giving a scenario where there has been a decision made by an administrative agency or a member of the executive that is an administrative decision in the sense that it probably affects the rights, interests, or legitimate expectations of a person. Would that be correct? Now,
Yes.
your question was assuming that a person is not interested in going to the AAT because what is involved is in fact a question of law. Is there a way by which it can go directly to the courts instead of going to the AAT? Is that a question?
But yes.
Okay.
Yes.
So if that is the question, and I'm not relating this to the factual background earlier given by the legal eagles, there are two ways of doing it. The first is, of course, under the Administrative Decisions Judicial Review Act of 1977. And under that specific law, if there is an administrative decision that a person wishes to question on the basis of a legal issue, then you have a recourse either to the Federal Circuit Court or the Federal Court of Australia. Okay, but in that case, it involves an administrative decision that is based on an enactment, broadly viewed. Now, what if the administrative decision is a decision, but is not based on an enactment? What then? So in that case, the Administrative Decisions Judicial Review Act of 1977 cannot apply. Now, is there a recourse to the courts if there is, if a person is aggrieved? The answer is yes, because if you look at the Judiciary Act of 1903, it again provides the Federal Court of Australia the power, for example, to issue writs of prohibition, mandamus, and injunction, which is actually a provision similar to that given by the Australian Commonwealth Constitution under Section 75 to the High Court. So under the Judiciary Act of 1903, the same powers which are given by the Constitution to the High Court of Australia has now been vested to the Federal Court of Australia. So again, in that case, it is possible for a person to seek recourse to the Federal Court of Australia. And we will also remember that there are common law writs which courts have long been recognized to issue in relation again to excesses or errors of law on the part of decisions made by the executive. So this could be writs for more than mandamus, prohibition, or injunction. It could be about quo warranto, for example, or it could be declaration, which we examine actually in the succeeding weeks. And again, in that case, these are writs, common law writs, which inhere in every court and can be used to seek a judicial remedy over an administrative decision, which may not be based on an enactment. So those are the remedies. And obviously, you have what is known as the constitutional writ, and that is based on Section 73 and Section 75 of the Australian Commonwealth Constitution, which relates to the power of the High Court in relation to Section 71. It is writs of prohibition, mandamus, and injunction. But in relation to Section 73, it is the power of the High Court when it concerns officers of the Commonwealth. So for example, if a decision is made by the Commissioner of Immigration or the Commissioner of Taxation, then Section 73 can be the basis for somebody to go to the High Court. But otherwise, those same provisions are actually duplicated in the Judiciary Act of 1903, particularly Section 51B, giving the powers to the Federal Court of Australia. So in other words, what happens is, it is very seldom for the High Court to actually entertain these types of questions. These types of questions would be better resolved by the Federal Court of Australia, because the High Court would like to limit itself to really important questions of law. Would that answer your question, Tony?
Yes, I think that adequately covered it. I see that as a problem because, well, no, just a problem for the people, because if you've got a tribunal decision against you and you do have an issue of law, but you might also have another issue, then you might end up going to the federal court and not getting your non-legal issues tended to, or you possibly could have gone to the administrative tribunal in the first place and had them change the decision of the tribunal anyway. So I think it makes it extremely complicated for the individual who's aggrieved on a potential case of court of law of
Thank you for your very decisive questions, but that again shouldn't really happen, because Administrative Appeals Tribunal really only looks at questions of fact. It cannot decide on questions of law, although it does, but only if, for example, the Administrative Appeals Tribunal has to, so on the basis, for example, of the Collector of Customs of New South Wales versus Brian Lawler Automotive, the ruling of the federal court was that the mere fact alone that a question of law has been raised will not divest an administrative agency or tribunal from entertaining a case. So the mere fact that a question of law has been raised. In other words, it is possible for an administrative tribunal to in fact touch upon a question of law, except that when that administrative tribunal touches upon a question of law, it is not decisive, it is not conclusive, and it is not final. Because again, decisions concerning questions of law are vested exclusively to the federal courts. That is according to the partial separation of powers of the Australian Commonwealth system of government. And so if what is involved is a question of fact, courts, so if there is a decision of an administrative nature and it involves a question of fact, courts cannot touch upon that. Because remember that the power of judicial review is of limited scope. It is limited only to legal questions. Now we know that there are instances when, although in general it should only be questions of law, we know that when there is no evidence, or when a decision is made where there is what is known as Wensbury unreasonableness, which touches upon kind of facts, then in that case, that is a question of fact, which actually involves a question of law. But in general, courts cannot entertain questions of fact. Now, in the same manner, administrative tribunals cannot come up with a conclusive decision when it comes to questions of law. In fact, if it is a question of law, then a person who's aggrieved should go to the courts and not to the administrative tribunals. Okay, so in other words, if I were an aggrieved, there are two questions, and I were the lawyer for an aggrieved, in other words, there are two questions I need to ask. One, does this administrative decision involve a question of law or a question of fact? So that will tell you where to go. Now, obviously, even if it's a question of fact, before you can go to the Administrative Appeals Tribunal, you need to find out if the decision is based on an enactment that provides recourse to the Administrative Appeals Tribunal, because if there is none, then you can't go to the AAT simply. Now, assuming, however, that you feel that you could possibly seek recourse with the courts, you need to find out if it's worth doing it, because not only is judicial review of limited scope, in other words, it focuses solely on questions of law and never on questions of fact. Remember that the judicial review remedies are quite limited. So they cannot remake a decision of the administrative agency. So they may remit, assuming that, you know, something eventually goes to the federal court or to a federal court. They cannot remake a decision. So they may remit that case back to the administrative decision maker. So you're looking at those possibilities, therefore. Now, having discussed that, we're kind of running out of time. So I think that was quite helpful, I think. I'm hoping it was helpful anyway. But I'd like to give, so Tony, would that be fine?
Absolutely. That was very good, and that's cleared up some confusion for me. So.
And thank you, Tony, for asking those questions. I'd like to move on now to the next group, which would be the Drakes. And the Drakes would consist of 1, 2, 3, 4, 5 members. We have Peter, Beerton, Megan Hiller. Well, I'll give yourselves a chance to introduce yourselves. So the Drakes, I give the floor to you.
No worries. Thanks, Manjo. Megan, if you want to share your screen with the PowerPoint, and we'll get started.
You got it there?
Yep, we see it.
Yep, thanks, Megan. All right, good evening, everyone. My name's Scott Webber, and I'm a member of the Drakes Administrative Law Group, along with Megan Hillier, Shavana Kumar, Luke Mead, and Peter Brereton. So tonight we'll be discussing merits review, and in particular visa cancellations under Section 501 of the Migration Act, and we'll also examine the case of Bruce Lomu. Okay, so Bruce was born in New Zealand in 1980, and then in about January 2010 he moved to Australia. Since arriving in Australia, he's been continuously employed by a WA Constructions company, which is a construction company in Western Australia, where he's built up a good, reliable reputation and has actually been promoted to foreman. So Bruce has no previous criminal history prior to January 2016, at which stage he was convicted for possessing dangerous drugs and was sentenced to a 9-month drug rehabilitation program. The Department of Immigration and Border Protection then ordered Bruce's deportation under the Migration Act. All right, Section 501 of the Migration Act allows the Minister to cancel a visa if certain requirements are met. And one of these requirements is that the person fails to pass the character test. Now, a person will not pass the character test if the person has a substantial criminal record or the person's been sentenced to a term of imprisonment for 12 months or more. Now, under the Migration Act, if a person has been ordered to participate in a drug rehabilitation scheme, the person is taken to have been sentenced to a term of imprisonment equal to the number of days of the scheme or program. So the Migration Act also provides that the Minister, when deciding if the person passes the character test, will have regard to either or both of the person's past and present criminal conduct and the person's past general conduct. Now, the Migration Act allows the Minister to cancel a visa directly, and this decision by the Minister cannot be reviewed by the AAT. However, a decision of the delegate of the Minister can be reviewed. Now, in 2014, the Migration Act was amended. Now, the Minister must cancel a visa if the person does not satisfy the Minister that the person passes the character test due to the person's substantial criminal record. Now, a person only has a substantial criminal record if the person has been sentenced to a term of imprisonment of 12 months or more. So Bruce is now appealing by the AAT to review the decision. And the AAT is an independent body entrusted with facilitating reviews of departmental decisions. Now I'll hand over to Luke, who will discuss the issues relevant to this matter.
Thanks, Scott. So several administrative law issues can be identified in Bruce's case. Firstly, whether the department took into account his past general conduct when making the decision pursuant to Section 501, subsection 6C of the Migration Act. This conduct can include references from upstanding citizens pertaining to Bruce's good standing in the community. Secondly, it needs to be clarified whether or not the department considered Bruce's past criminal conduct under the same provision. A secondary element of this issue is that the department classified Bruce's previous criminal conduct as substantial, giving rise to a possible error of judgment which can be reviewed by the AAT. Thirdly, the department has made the decision under section 501 subsection 3 capital A. It needs to be decided if they are able to do so under this provision, since this provision gives power to the minister to make the decision. Because Bruce is appealing to the AAT to review the decision, the AAT needs to consider whether the decision is actually able to be reviewed by the AAT under the Migration Act. As I said before, the department may have erred in its judgment when deeming Bruce to have a substantial criminal record. This is an issue that the AAT will need to investigate into. If it is found that there is no error in judgment, then the AAT will have to decide if Bruce actually passes the character test under section 501 subsection 6C. Another matter for the AAT that the AAT will need to investigate and decide upon is whether or not relevant or irrelevant evidence was taken into account when the original decision was made. In reviewing the decision made by the department, the AAT will need to decide if the correct and preferable decision was made. I'll now pass it over to Peter, who will discuss the principles and rules.
Thanks, Luke. In Bruce's case, the AAT has a wide variety of powers to apply. They can, 1, affirm the decision, in this case by agreeing with the cancellation, 2, vary the decision by suspending or putting conditions in place, or 3, set the original decision aside and make a substitution or recommendation for the decision to be reconsidered. When the AAT is considering decisions, they have a broader capacity to not only consider the legality of the decision, but also to consider if the decision made originally was a correct or preferable decision. When considering the facts before it, the tribunal will review primarily if the law applied was correct, and secondly, whether it was enforced preferably. The rationality applied to a decision may permit more than one preferred decision based on the facts provided, as in the Minister for Immigration and Ethics Affairs and Wu Shan Liang, where the court commented a whole range of possible approaches to decision-making in the particular circumstances of the case may be correct in the sense that their adoption by a delegate would be an error of law. Would not be an error of law. Where there are no facts to support the findings of the original decision maker, this would be purported to be an error of law. Reviewing tribunals such as the AAT are not bound by policy, but they will be reluctant to part from policy without good reason. This has been the position ever since the landmark decision in the Drake case. This was further distinguished at the merits rehearing where His Honour Justice Brennan commented, if the tribunal applies ministerial policy, it is because of the assistance which the policy can furnish in arriving at a preferable decision in the circumstances of the case as they appear to the tribunal. The tribunal, however, is free to consider what information it deems necessary to arrive at a decision. One of the factors to be considered in arriving at a preferable decision in a particular case is consistency with other decisions in comparable cases. And one of the most useful aids in achieving consistency is a guiding policy. As can be seen by Justice Brennan's established in the matter of Becker in the first hearing, and he subsequently reiterated in the Drake case. From the information provided, it would appear that Bruce has the grounds for the decision to be reviewed at the AAT. Any questions?
Thank you. That was a very good presentation. So let me just begin first. In terms of the organization, I actually gave a mark of 25 for the group. So let me just state that first. I'd also give 25 for the presentation. So that's 25 out of 25. In terms of the response, I'll mark you after I ask a few questions. The content, I've got some concerns about the issues that you've identified. And I've got some concerns as well as to the legal rules that you've cited. I'm not convinced that you've actually succeeded in distilling what the proper legal issues are. Can you just go back to that slide about the legal issues? So I'd like to provide some comments.
Sorry.
So you did well. So the group did well. And if you notice, if the rest of the class noticed, the group relied on bullet points. They used bullet points. So they were not just reading from, verbatim from a script. Well, at least nothing noticeable to me. So the bullet points are there to guide both the listeners as well as the presenter. But you do not read off what is on the screen, because otherwise that's really difficult to do. If you try doing that, you know, like somebody's talking to you, then somebody else is asking you to read something, it can't be done. That's called cognitive overload. Okay, so let's look at the, let's go to the issues. Okay, there. So let's look at this. So we won't have the time to go through everything, okay? So I'm giving a feedback here for the purpose of the individual research essay. So let's look at one of the first issues I've identified. It says whether the department took into account Bruce's past general conduct. That is not a legal issue. That's simply a factual question. Second question, the second question was whether the department did not consider Bruce's past criminal conduct. Again, that's a factual question. Whether the department has the power to cancel a visa under Section 501, that is not a legal issue. That's simply a factual question. You go to the law. Now, to me, okay, I can't really provide the legal issue, but you will get a sense by me asking some questions. Did you get that? I'm not convinced that the legal issues have been properly identified. Now, let me explain whether the decision is reviewable. That is not a legal issue. That's simply a factual question. That answer depends on the law. That is on which the administrative decision was made. Whether or not it allowed a review by the AAT, that's a factual question. So I'm not going to provide you the legal issue because that is your job. But with my questions, you will get a sense of what the proper legal issues are. But before I get there, let me just provide some reasons why we need to really identify the legal issue. So in general, by now, you would have heard of, obviously, of the SIRAC and the IRAC format. So you begin by identifying what the legal issues are. After you do that, you come up with the rules, then you apply the rules to the facts, and then you come up with a conclusion. That is the conventional way of arriving at an answer when you are dealt with a legal problem. That is universally used, and it's very popular. The reason is simple. Because if you follow that format, you actually arrive at the correct legal conclusions. In other words, if a client came to you with a problem, with a factual problem, your job as a lawyer will be to identify what exactly are the relevant legal issues here. It's not about coming up with identifying the factual questions. Your job as a lawyer is to identify the legal issue, because if you identify the legal issue, you will then be able to provide the proper legal advice. So why is the legal issue important? Because if you identify the legal issue properly, you will then be able to articulate what the proper relevant rules are. So what exactly are the legal rules or principles that need to be taken into account and that will inform the legal issue? So the legal issue does two things. One, it leads you to identify what the proper rules are, or the legal principles which are related to the legal issue. So in other words, any rule that does not address the legal issue, you don't discuss that because that is irrelevant. Okay, so that's one. But the second purpose of identifying the legal issue is that you then actually delimit the discussion you're going to make. Any discussion of the legal rules and principles you're making will have to be limited by what are the legal issue. So those two are related. So are we clear? Now, if you've articulated what the legal issues are properly, and then you've identified what the legal rules and principles are, you are then able to apply those legal rules and principles to the facts. So then you say, these are the rules, and if we apply these rules to the facts, then we can conclude as follows. So you can see the logic there. Okay, so without identifying the legal issues for you, because that is your job, let me just ask some broad questions. The first question I ask is, it was clear that somehow the minister focused on the criminal record of that single criminal record of Lomo, Mr. Lomo. The question I ask is, did the minister make an error, whether a fact or of law, in failing to account for all potential factors relating to LOMO. So was he required, for example, to look at the good standing of LOMO in the community, his previous job background, how good he has been at work? Was the minister required to examine his financial capacity? And if the minister failed to do that, would that be a basis for a merit review for the AAT to consider? So that if the minister failed to consider all of those factors, and especially if the minister zeroed in on the conviction, did the minister commit an error which could then be the basis for an AAT review? So can I get an answer from the group to that question?
Yeah, Manjo, Scott here.
Yep.
I think he has, because he cannot. The Legislation Migration Act doesn't allow him to cancel a visa for a person for failing to pass the character test because of a substantial criminal history, because he must have been sentenced to a term of imprisonment of 12 months. So therefore, the only lawful instrument for the cancellation of the visa is 5016C, which allows the minister to cancel Bruce's visa because of his past and present criminal conduct and his past and present general conduct, establishing that the person is not of good character.
My question was, would the minister have been in error if he failed to account of all those other factors? So standing in the community, money might have, how good a worker he was.
Yeah, and that's where I was heading with that, Manjo, because the minister failed to take into account all those things, his general conduct, his criminal conduct, then he has erred in his decision.
Okay, so let me just flag you on that. That is likely a wrong answer. Have a look. That answer is not correct. Or maybe I should tell you.
Yes,
the
please.
minister is only required to consider all those factors if it is required by the legislation. If it is not, so I think this is part of week 6. If he is required to take into account those factors, then he must. But if he is not required by the legislation to take account of those factors, then he does not have to. So the mere fact that he does not take into account those factors will not mean that he has erred. So just have a look. Okay, now, okay, we've run out of time. I would have, go Scott.
Yeah, so I'm a little bit confused, because the Migration Act actually says that a person does not pass the character test if sorry, I'm just reading it here. For the purpose of this section, being the character test, a person does not pass the character test if, having regard to either or both of the following: the person's past and present criminal conduct, the person's past and present general conduct, the person is not of good character.
Okay. Again, when I asked that question and when I gave the answer, it was a broad question and a broad answer. I'm not referring to the particular provisions of the Migration Act. So as a matter of principle, if a decision maker fails to take account of certain factors, that by itself will not vitiate the decision. A decision maker is only required to take account of certain factors if he is required by the legislation, if he, in broadly viewed, okay? So, but if the legislation does not require that, then he is not under a legal obligation to take those into account, so that his failure to take those into account will not mean that the decision is wrong. So I'm stating a broad principle of law. Okay, so thank you for that. And I guess we should move on. So I've given the following scores to the group, 25 for organization as pointed out, because I pointed out in my email that I was going to provide a feedback directly. So, you know, it's not going to be in the form of a Word document. The presentation was 25 out of 25. The content is 20 out of 25. The responses would be 22 out of 25. So you did really well. So that is a high distinction for this group. Well done. So well done, Peter, Megan, Shivana, Luke, and Scott. Thank you very much. I could see that you're really prepared for this presentation. Thank you so much. I'd like now to give the floor to the next group, which would be the triple threat, consisting of Marjorie, Caitlin, and Kim.
Hi, Manjo. I'll share the screen now.
Thank you.
Can't share. Can the other team close?
The first group, you're going to have to stop sharing the screen. Thank you.
Okay. Okay, good evening, everyone. We are looking at the merit review, the case of PNMJ and her parents. The group that I'm with is Triple Threat, and we are made up with Marjorie Foley, myself, Kim Porter, and Katie Ann Seymour. The case that we'll take into question is that of PNMJ and the National Disability Insurance Agency from 11 November 2015, and I'll now hand it over to Marjorie to present the background of the case.
The factual background of the case is set out as follows. In July 2013, the Australian government introduced the National Disability Insurance Scheme Act to help provide the reasonable and required support needed by individuals and families alike that were having difficulties in dealing with people with disabilities. The aim of the Act was to provide support to families who were under the pressure of dealing with individuals who were unable to do daily tasks without constant support and supervision. This Act allowed professionals to intervene at an early stage to help exercise the choice and controls that were available to help take the pressure off families and carers while allowing them to achieve future goals. PNMJ is a 3-year-old child who since birth has had multiple and serious complex disabilities that require her to receive constant supervision. Since she was born, she has met the early intervention requirements that are set out in the National Disability Insurance Scheme Act and is a participant in the National Disability Insurance Scheme. On the 4th of November 2014, a plan was approved by the National Disability Insurance Agency that included funding for a total care package with provisions for 136 hours per week of care on a 6-month trial basis. On the 16th of April 2015, PNMJ's father came forward suggesting that the plan was currently in place should be reviewed as the family deemed that PNMJ needed 24 hours per day care. The National Disability Agency reviewed the plan at the request of PNMJ's father and came to the decision that a total of 136 hours a week was ample amount of hours for the care based on PNMJ's disabilities. On the 28th of April 2015, PNMJ's father sought review by the AAT of her support hours and asked for certainty throughout the duration of her plan. PNMJ's parents say that funding for full-time in-home carer is reasonable and necessary within the meaning of the National Disability Insurance Scheme Act. The general principles by which actions under the NDIS Act are to be guided include that people with disability, including their families and carers, should have certainty, that people with disability will receive the care and support they need over their lifetime, that people with disability should be supported to receive reasonable and necessary supports, including early intervention supports, and the role of families, carers, and other significant persons in the lives of people with disability is to be acknowledged and respected. Furthermore, the NDIS Act provides the information as to specifying in a statement of participant supports the reasonable and necessary supports that will be funded under the NDIS. Subsection 34(1)(e) of the NDIS Act states, the funding or provisions of the support takes account of what is reasonable to expect families, carers, informal networks, and the community to provide. In plans approved on the 29th April 2015 and 13th of May 2015, adjustments were made which led to relatively modest increases in funding. On the 19th of August 2015, a plan was approved which led to a substantial increase in funding. and like each adjustment on PNMJ's approved plans, no further information has been provided about it. Furthermore, although the plan has made changes to other supports, it has reiterated the decision concerning the funding for 136 hours for 6 months. Accordingly, under the NDIS Act, once the Chief Executive Officer conducts a review under Section 48, a new plan must be prepared. In addition, a participant's plan ceases to have effect when it is replaced by another plan under the NDIS Act. On the 11th of November 2015, the funding for 168-hour each week was considered reasonable and necessary for PNMJ's care. This plan was to be in place for 6 months and then reviewed again to see if there are any adjustments that need to be made to ensure that PNMJ and her family are receiving the best help that they can be afforded to them. I will now hand in to pass this on to Katie for the issue, significance of issues.
Okay, so the significance of the main issue and the key issues as they relate to administrative law will be discussed next. So in a world of harsh reality, a review of the NDIS decision made in relation to support provided to PNMJ's family leaves the fundamental question for the AAT to consider whether the approval of 136 hours of in-home care per week is reasonable or necessary under the NDIS Act, or whether the funding for the additional care should be approved. So what does this mean for PNMJ's family, for individuals and or other families who currently receive funding or who may seek funding in the future? And what does it mean for the NDIS as a whole? These are serious questions with serious consequences, regardless of which decision is ultimately made. If the AAT rule in favour of PNMJ's family, they potentially increase further actions of review from existing individuals and or families who may seek additional funding. What's more, they set a precedent for future individuals and or families requiring funding. Though this is a positive for the families, the AAT need to consider whether or not such action will give rise to reduced funding available to the NDIA in the future. Further, the NDIA under the scheme receives set funding, and if it were to give more hours and subsequently award more funding support to each family, then this may in turn limit the amount of individuals and families who may receive funding in the future. This is the dilemma of the AAT that they must consider when making their final determination. So as previously mentioned, the main issue to be considered by the AAT is whether funding for 136 hours of in-home care for PNMJ each week is reasonable and necessary, or whether funding for additional care as requested by PNMJ's parents should be approved. In order to adequately address the main issue, sub-issues arise such as 1, was the CEO's decision to vary PNMJ's plan to increase the funding correct under the Act? Why or why not? 2, was 168 hours per week approved funding reasonable and necessary under subsection 34(1) of the Act? Why or why not? And 3, what value or principles of administrative law has the National Disability Agency failed to provide? I'll now pass on to Kim to talk about the administrative law rules.
Thank you, Katie. So in order to consider the issues, the AAT must apply the rules that are permitted, which are set out under the boundaries of the relevant authorities.
2 minutes to go. You've actually ran out of time. I did notice I muted myself, so I wasn't able to warn you. I'll give you an extra 2 minutes.
I'll probably only be another minute at most.
Okay, thank you.
Okay, so the authorities are the National Disability Insurance Scheme Act and the Administrative Appeals Tribunal Act. So the rules as we look at them are the AAT permitted to review the decision? It's important to determine if they are able to review the decision to consider the actual supports that are required by the family of PNMJ, or determination of the funding hours, where it considers the funding hours and the AAT is permitted to review the matter. Is the matter to be reviewed a reviewable decision in accordance with the purpose of the AAT Act? Where it's not reviewable, then it may be more applicable for the family to take the matter through the court. Careful consideration does need to be given here, as it's imperative that the matter is heard through the correct avenues. Can the Act objectively and be just in its role to ensure that it will act fairly in considering the material put before it? And can it deal with the matter to prevent it being dealt with through the courts, which we looked at in point 2 above? This is the ultimate aim of all legal matters, to deal with a matter through any means first, which may prevent it going to court. Tribunals have been set up to discourage a matter going to the court, which is ultimately very costly, potentially both parties. Can it provide a decision in a short period of time? This is a fundamental step. There's no point participating in a tribunal review if it cannot be dealt with in a timely fashion. To create delays unnecessarily or to take a matter that cannot be completed in a reasonable and short time frame would be irresponsible of the tribunal. And finally, is the applicant requesting the review a reasonable person whose interests are affected? This is a two-step approach that requires the tribunal to consider the question of a reasonable person whose interests are affected. Not only must it consider what is a reasonable person in view of one's peers, but it also needs to take account of the potential interests of that person and what are affected. The AAT has no jurisdiction in acting outside of the rules that are set out under the relevant authorities. We take the opportunity to thank you for listening, and we now ask you for your questions and/or your comments.
Okay, thank you so much. So let me give my feedback. I think that the group did substantial preparation. I could see that in the form of the PowerPoint slides. And just like the prior group, the Drakes, you used points which again allowed both the listener as well as the presenters a way by which to traverse certain facts and issues by just focusing on the key points instead of having to read each word that is in a document. So that's good. So I could sense it was presented well. The organization was also very good. So I would give the group 25 out of 25 for organization. For the presentation, same thing, it's 25 out of 25. Now, as to content, I'm quite confused in relation to the rules, because the rules came up with questions. And some of those questions were in fact not even administrative law questions. They were just political science questions. So you need to focus on the rules there. So instead of asking questions, give us the rules. So in fact, the rules should be linked to the legal issue. And I found that surprising, because the legal issue actually would have turned on the concept of reasonable and necessary. And I didn't find the rule concerning that. So that's what got me confused. So there needs to be some work there. Now, let me just ask a few questions, and then I'll provide further comments. The first, I'll begin with a factual question, because I got confused by this. On the one hand, there was in the facts, you had said that what was awarded was 136 hours per week of care. And in the next one, it was 168 hours of care each week. In relation, for example, to the second one, what's the problem with that? Why would the father of PNMJ complain if there was an award for 168 hours, which actually translates to 24 hours of care per day for the 7 days each week? What's wrong with that?
Manjo, this is Marjorie.
Yes.
At first, PNMJ was actually awarded 136 hours, but the problem there was there was uncertainty in providing those hours, because there has been because of PNMJ's complex disabilities, they were actually having, even though they were funded 136 hours, they were actually not getting the 136 hours. In fact, they were still in credit for the 136 hours. Now, PNMJ's father thought that they actually need more than just 136 hours. They needed 168 hours of care.
So
if that makes sense.
Yeah, those facts were not evident both in the presentation as well as in the MS Word document that you submitted. But that got me confused. So it's not a question of the award simply being 136 hours initially, but the fact that there was some uncertainty in that being given. Was that it? So that should have been clarified. That was quite confusing. And in fact, eventually when the decision was to award 168 hours of care each week, which actually translates to 24 hours per day, I can't see a problem with that. Is that really possible? to award 168 hours? I was thinking that there's a factual error there somewhere.
They were trying to ask for that 168 hours
24
after
hours
they got that.
per day.
Yes, because of the complexity of her disabilities. But the whole problem is, even though they were awarded initially for 136 hours, there were not enough carers nearby that are actually available to care for her.
So what I'm saying is, when you work on the individual research essay, I think those facts need to be clarified because they were quite vague. I didn't.
Okay.
Okay, because that is actually crucial to understanding what was going on. So the way it was written, when I went through the factual background, there were some errors there which were confusing to me. It wasn't clear to me what the problem was. So I think you need to address that. Now, the broader concept that needs to be addressed is the issue about reasonable and necessary support. My question is, this criteria of what is reasonable and necessary support, is that a question of law or is that a question of fact? And that's a question for the group.
Well, it's a question of law, Manjo, is it not? It's within the Act, they determine what is, well, they're not very clear about it, but they do talk about that it needs to be considered reasonable and necessary. So that's taken into account in the Act, which would tell me it has to be a part of the law.
The thing is,
am I mistaken?
You probably are. The thing is, if it's a question of law, then you don't go to the AAT, you go to the courts, wouldn't you?
Yes, but this is also stated in the National Disability Insurance Scheme Act that if they have problems with certain issues on this law, it is reviewable under the AAT.
Well, why would reasonableness and what is necessary support? Why would those be legal questions? Why aren't those factual questions? How can a court determine what is reasonable? How can a court determine what is necessary by looking at the law? Wouldn't that require looking at the facts? And wouldn't that require discretion? Wouldn't that require policy questions? I raise these questions because the answer should have been, if you examine the previous concepts we've been discussing, this is not a legal standard that courts are in a position to actually answer. This is a factual question, which is really just for the decision maker to make. If you bring this to the court, on what basis will a court say that it is reasonable without going to the facts? And so if the court goes to the facts, it means it's not a legal question. It is a factual question. So I'm just flagging that for the group. Okay. Now, it's 7:09. I actually have a class in a few minutes. So having said that, take that into account. So there is something you need to address, that issue about the reasonable and necessary standards. And the rule, again, you need to dig into what is a legal standard or a legal question and what is a factual standard, a factual question, which means that it is beyond the scope of judicial review. So you need to address, is this problem, is this, given the factual background that you gave, is this problem properly one that should be dealt with by the courts? Meaning, is it better to have judicial review because it involves a legal question, or is it really one that requires a merit review because of the factual questions involved? So that is one of the legal issues you need to address, especially when you go to the notion of reasonable and necessary support. So I'm just flagging that to the group. So having said that, I gave the group 19 for content out of 25. And in terms of response, I gave you 22 out of 25. So the answer may not have been very correct, but I'm persuaded by your attempt to answer it, and you did cite the relevant law. So that's still a high distinction. So well done to this group. Well done. And I'm hoping that the future groups, when they do their presentation, will be able to deliver the same quality of presentations that we have seen so far. So well done, and thanks everyone for joining tonight's presentation. I can't stay long because I've got a class in a few more minutes. So thank you. Well done.
Thank you.
Good night. Bye.